The shock hit instantly, decisively, like a legal thunderbolt slamming straight into the heart of America's gun control system. No warning, no leaks, no media whispers. Just a sudden December Supreme Court order that ripped through the political landscape and sent lawmakers, governors, attorneys general, and anti-gun lobbying groups scrambling for answers. You could almost feel the jolt across the country. Phones started ringing. Emergency legal calls erupted in state capitals. Governors ordered immediate briefings. And gun rights advocates? They instantly knew what had happened. The Supreme Court had just taken a step so big, so bold, and so far-reaching that it might permanently reshape the future of firearm ownership in the United States. December is no longer just another month on the calendar. It's the moment everything changed. What the court issued wasn't a typical procedural action or a quiet administrative note buried in legal jargon. It wasn't a minor clarification or a harmless reshuffling. It was a decisive order with massive implications, signaling that the justices are preparing to strike deeper into the Second Amendment debate than anyone predicted this year. The December order opens the door to major constitutional shifts, dramatic legal reversals, and a direct confrontation with the most controversial gun laws in modern America. It forces states, whether they like it or not, to brace for a new legal reality. Across the country, 7 specific areas of gun policy are now in immediate jeopardy. The court's order all but guarantees that major changes are coming, and if state officials don't move fast, they're going to be blindsided. These updates affect licensing laws, permitting requirements, carry restrictions, sensitive place designations, waiting periods, assault-style weapon bans, and even long-standing registration systems that have defined firearm ownership for decades. For millions of gun owners, these shifts aren't just policy changes. They are the biggest constitutional realignment since Bruin. December's Supreme Court order started with a case that many assumed would stall, drag on, or get quietly ignored. Instead, the justices grabbed it with force. They froze a lower court ruling that upheld strict state requirements and, more importantly, issued language signaling that the court now sees major constitutional conflicts in the way states control who can buy, carry, and possess firearms. This one move triggered a chain reaction because the court only intervenes like this for one reason. It believes the lower courts got the Constitution wrong. Immediately, legal experts recognize the pattern. When the Supreme Court steps in early, it's often preparing for a seismic ruling. Exactly what happened before Bruin, before Heller, before McDonald, and now, potentially, before the largest Second Amendment overhaul in a generation. December's order isn't the final step. It's the explosion before the earthquake. The first major issue affected is state licensing authority, an area that has always been a legal minefield. States like New York, New Jersey, California, and Maryland have built entire systems around requiring citizens to apply for permission before they can buy or carry firearms. These systems include everything from character references, interviews, mandatory training, exhaustive background checks, fingerprints, fees, arbitrary wait times, and, in some cases, moral character tests. But now, the Supreme Court's December action signals a massive shift. These systems may be fundamentally unconstitutional. The court is poised to address whether a right can require government permission, and if the justices rule that it cannot, the entire licensing framework collapses overnight. The second major area under threat is the use of sensitive place bans, which exploded after Bruin. States like California attempted to designate nearly everywhere: malls, parks, sidewalks, parking lots, public transportation, churches, stadiums, hospitals, and even certain neighborhoods as prohibited carry zones. Anti-gun lawmakers believed they found a loophole. If they couldn't stop citizens from carrying in general, they would simply ban carry everywhere else. But the Supreme Court's December order hints that these tactics violate the Constitution. The court may soon impose strict limits on when states can declare an area sensitive, closing the loophole permanently. The third issue now under review is far more controversial: assault-style weapon bans. December's order is a direct signal that the court sees massive constitutional problems with states banning firearms in common use. Millions of Americans own AR-15s, semi-automatic rifles, and standard capacity magazines. The December order suggests the court is preparing to confront these bans head-on. While the final outcome is not yet written, the legal direction is clear. States cannot prohibit firearms that are widely owned for lawful purposes. If the court follows this logic, most assault weapon bans will not survive constitutional scrutiny. The fourth issue affected is magazine capacity limits, which anti-gun lawmakers often claim make society safer. But the Supreme Court's December order indicates the court is skeptical of these restrictions. Magazine limits have no historical analog, meaning they fail the Bruin test. If the court addresses this issue in the upcoming case cycle, these limits are likely to fall. The fifth area under immediate pressure is waiting periods. Waiting periods were originally justified by emotional rhetoric, not constitutional history. They force law-abiding citizens to delay exercising a fundamental right. The December order signals that the court may view these delays as unconstitutional barriers, especially when there is no relevant historical tradition requiring citizens to wait days or weeks before obtaining a firearm. The sixth major issue is firearm registration systems, such as California's mandatory registration of assault weapons and Hawaii's registration procedures. These systems force citizens to surrender information to the government simply to exercise a right. Registration has no historical equivalent and therefore sits in a constitutionally vulnerable position. December's Supreme Court order suggests the justices may finally address whether forced registration is compatible with the Second Amendment. The seventh, and perhaps most explosive, area is the use of discretionary government power to approve or deny firearm access. This includes moral character reviews, subjective evaluations, local police discretion, and agency authority to grant or deny permits based on criteria not found in constitutional text. The Supreme Court's December order implies that discretionary power is incompatible with constitutional rights. If the court strikes down discretionary authority, millions of Americans will no longer depend on government judgment to exercise the right to carry or own a firearm. But beyond these 7 specific updates, December's order carries an even larger message. The Supreme Court is taking direct aim at states that have openly resisted Bruin. In 2023 and 2024, several states passed laws designed to circumvent Bruin by layering new restrictions that were technically different but functionally identical to the ones already struck down. These states assumed the Supreme Court wouldn't intervene quickly or aggressively. They assumed wrong. The December order is a warning shot, and a serious one. Across the country, activists, attorneys, and advocacy groups are reacting with a mix of excitement, panic, and uncertainty. Gun rights organizations have already begun drafting emergency briefs and planning litigation strategies to capitalize on the court's December signal. They believe the coming year could deliver the biggest wave of gun rights victories in American history. On the opposite side, gun control groups are sounding alarms. They're warning their supporters that decades of legislative progress are about to be undone. State officials in restrictive states are scrambling. Emergency meetings are being held. Legal memos are being drafted. Governors are asking their attorneys general how to defend laws that may no longer be defensible. Legislatures are preparing for a legal war they didn't expect in December but must now confront immediately. No matter how hard they push, the Supreme Court has already set the tone. The Constitution, not political pressure, will decide the limits of firearm regulation. One part of the December order has especially stunned legal analysts. The language implies the court may soon define a strict national standard for firearm regulation. If the court goes that route, it would eliminate the patchwork of inconsistent rules that differ wildly state to state. Gun owners in California, New York, or New Jersey could soon enjoy the same rights as gun owners in Texas, Florida, or Arizona. That would be nothing short of revolutionary. But the biggest question sparked by the December order is this: why now? Why December? Why such a sharp intervention at a moment when the country is deeply divided on firearm policy? Experts believe it's because the court has reached its limit. For months, states have openly challenged Bruin, crafting laws that, according to Justice Thomas, evade, defy, or openly contradict the court's constitutional framework. The justices are sending a message. The Constitution means what it says, and states cannot simply ignore Supreme Court precedent. Inside the Supreme Court, several justices have made it clear that the Second Amendment is a fundamental right that deserves the same respect as the First Amendment. And in December, they acted on that principle. They didn't wait for new tragedies or media narratives. They didn't allow political pressure to influence constitutional interpretation. Instead, they reaffirmed the court's responsibility to enforce the Constitution as written. The December order is just the beginning. The court is preparing for a blockbuster 2025 session that could transform the legal landscape. If the justices decide to fully address the 7 major issues highlighted in this order, America may be on the verge of the largest expansion of gun rights since 1791. Every gun owner must pay attention because what happens now will define the future. Gun rights supporters say the December order is a long overdue correction, one that restores the balance of power between citizens and government. Gun control advocates say it's a dangerous escalation. But no matter which side you're on, the reality remains. The Supreme Court has spoken, and they are not backing down. The next few months will be intense. Lawsuits will multiply. Courts will issue emergency injunctions. States will scramble to rewrite their statutes. Activist groups on both sides will fight for influence. And through it all, the Supreme Court will continue shaping the future of American freedom. Because December wasn't just a procedural moment. It was a turning point, a constitutional reset, a nationwide signal that the Supreme Court is ready to reassert its authority and define, once and for all, what the Second Amendment truly protects. And for millions of gun owners across the country, the message is clear: a new era has begun.